Welcome to this free immigration help channel. Today is March 22nd, 2023, and we are getting into the volume 38 of me going through all your questions and answering your immigration questions and comments. And if I haven't mentioned already in the previous videos, just like I've always mentioned, I'm going to mention it again. This is not an immigration advice. I'm not an immigration attorney. All the information that I provide on my videos on this channel are directly from official government sources like USCIS and the Department of State. So without further ado, let's start with the first question comment from Adisra GTPon. And I'm sorry if I'm mispronouncing the names. It works with I-94 but not travel history. Wow, that is interesting. I actually never heard of a case like this. Usually it either works with both or it doesn't work at all whenever it comes to pulling up the I-94 arrival departure record on the CBP website. So if it's not working in the travel history, most likely there was some mistake that was made somewhere along the way. So if you really do need that information, the travel history, if you really do need to pull it up, then you would have to contact the CBP, as I have described in this video that you commented on, basically treating it as the record not found. On the plus side, you do have the I-94 record, so it would be a little bit easier because you can actually put the I-94 number and say, hey guys, this is my I-94 number, and for this number the travel history is not coming up, so can you please take a look into it if there is any kind of error in that. But that's very interesting situation. Thank you actually for sharing. I haven't seen anything like this before. Yeah, this is new. All right, let's move on to the next one from Binyam Desta. Do you know how long it will take for B1, B2 interview waiting time? So whenever it comes to B1, B2 non-immigrant visa, you don't really wait for an interview. You go yourself to the US Embassy's website in the country, wherever you're planning to do your interview, and you register for an interview. Depending on how long you're gonna wait, how fast you can schedule it, it will depend on how busy that US Embassy is. But usually, in most of the cases, you can schedule the interview as soon as, next week. Especially now, a lot of US embassies, they experience a lot of backlog because they've been closed for, this whole pandemic situation. But now, all of them are back up and running, so they are catching up. So it's really this week, next week you can schedule the non-immigrant visa interview. It's pretty straightforward, but you would have to check out the website of the local US Embassy and usembassies.gov. If you go, you will have the list of all the countries where US embassies are. Just find it if you don't know your local US Embassy, and on their website you will be able to schedule a non-immigrant visa interview. Alright, moving further to Simba Mike. What does this mean? Your case is taking longer than expected to process. You do not need to take any action at this time. Okay, Simba, great question. So that means that wherever your case is pending, whether it's USCIS or NVC, I'm assuming this is USCIS because that's what it sounds like. This is something that they would say. I would definitely recommend taking some action because if it's already outside the normal processing times, you have all the rights to know why it is outside the processing times. So if it's still with USCIS, then I would highly recommend. You don't have to do that. I mean, whenever it comes to the processing times, usually the estimate is for 80% of cases, all right? So your case might be in that 20% that is just taking a little bit longer to process for whatever reason. Maybe it's in the service center that's a little bit overwhelmed. Maybe it is in a specific immigration officer that just didn't get to it. There can be plenty of reasons. It really doesn't matter. I would still recommend submitting an inquiry with USCIS. I actually have a video on how to submit the inquiry with USCIS. If it's with NVC, because you are asking you didn't specify which case it is. If it's I-130, if it's the petition for alien relative, it might be with NVC and it's pending. If it is with NVC, then submit the public inquiry form with the Department of State, and I actually have the video on that as well. But I would not listen to the you do not need to take any action, because since your case is already outside of processing times, you have every right to know why. So definitely take action and submit the inquiry. It's not gonna hurt, just in your inquiry, always be professional, always be polite, because you're sending a letter to the government. You don't want to hinder their relationship. All right, moving further to Vinu. Hello, sir. I have applied for my asylum, but my case is pending status now. I wanted to get and marry my girlfriend from my home country, so how can I take her on my dependent or any other chances? Please help on this. Okay, Vinu. Actually, interesting question. I'm gonna ask you a follow-up question, and if you can answer, I might be able to provide a little bit more information. Is your girlfriend here in the United States, or is she still back in the country where you came from? Because if she's here in the United States, it simplifies the process quite a lot. Because once you get married here, that's it. Pretty much automatically she's already part of the case. You will have to do a few things. You will have to update depending on, let's say if you didn't have the interview yet, once you go for an interview, I would update the local asylum office where your case is being processed. In fact, I would just contact them and say, hey guys, I'm married. She's also, from my home country. She's here, and I want to include her as a dependent on my application. What do I need to do that? Most likely, it's very simple, straightforward process where you just submit a cover letter, you submit her information, and that's really it. If it's already in court, the way it works, you're just going for a master hearing together with her, and you say, Your Honor, to a judge, here's, I got married while waiting for my asylum to be processed. She's here with me. I would like to add her to my case. Very straightforward, no problems at all. It makes it a little bit more complicated if she's not here and if she's over there, because she, being over there, she cannot qualify for the same asylum status. Why? Because asylum status is only for people who are in the United States of America. So for her, obviously, to come here, she'll have to figure out the way to come here. It might be on a fiancé visa. It might be you can't really do any non-immigrant visa as a pending asylum, unless she does like a tourist visa. But again, it's not really going to be applicable in her case. Why? Because she will have plans to immigrate to the United States, obviously, because she's marrying someone who is claiming asylum in the United States. So once she goes to the US Embassy, you don't want to have that contradiction, because the chances of them denying her application for a non-immigrant visa will be very, very high. Another thing that you have an option for is you can wait for that asylum application to be approved, and then you can submit a petition 730, which I'm going to use a quick navigation demonstration of USCIS. This is the official USCIS. You're probably already familiar with this website. Click on the forms, all forms, and I always mix up the numbers, but I don't think I did it this time. 730, there you go. So it's a refugee asylee relative petition. Once you have the granted asylum status, you can submit that petition for her to come here into the United States as a relative of someone who's been granted asylum. So there you go. I gave you a few options. See which one works for you better. And if you want to follow up with your answer, just submit a separate comment. Don't respond to this, and it goes for everyone who's watching this video. Please don't submit the responses within your own comment, because then I don't see it. For whatever reason, YouTube does not give me those notifications. Those comments do not appear on my wall. So if you are following up with an answer or something, or you have a follow-up question, make sure to submit a separate comment. All right, let's move on to the next one. From Freewood Demisi, thank you very much. Really, you're working best. Thank you for watching. Thank you for asking questions. Without you asking questions, I wouldn't have these videos. All right, so it's 50-50. You're asking me, I'm answering. All right, let's move on to the next one from Zara Kazemi. I'm Citizens, California. I applied for my daughter and her husband and her son on May 2017. How F3? Okay, so I'm assuming that's F3 category, third priority category. I don't get any letters or emails from USCIS. Just, I got case number. Please advise me, what can I do? Please answer me. Okay, so let me think. So you're a citizen. Let's take a look how long it takes with USCIS first. And again, that's another opportunity for me to demonstrate the navigation on USCIS. We're gonna go to tools this time. and we're gonna click on case status online. And because you have the case number, this is where you can enter it, and that should tell you where your case is in the process. So I definitely recommend you doing that. But there's another thing that I want to do, is I want to go to the processing times, and let's see, so it's going to be I-130, and you're a citizen inviting your married daughter. So U.S. citizen filing for spouse, U.S. citizen filing for unmarried, U.S. citizen filing for married son and daughter. There you go. So this is going to be for us, and it's going to California Service Center. Get processing time, 117 months. And because my math is horrible, I'm actually going to use a calculator. 117 divided by 12. 9 years and 7. Okay, so looks like the California Service Center, specifically for these petitions, they wait for the immigrant visas to become available. Don't let that scare you too much. I know sometimes, you know, for example, if you compare this to Texas Service Center, I'm pretty sure it's going to be much less. Yeah, see, it's much less. It's less than 3 years. Now, it doesn't mean that the processing in Texas, you're better off with Texas. It just means that in Texas, the USCIS part will be processed faster and then sent to NVC. And then you will be waiting the same amount of time at the NVC because there is a backlog on the immigrant visas specifically for the F3 category. All right, and it is, well, right now, there's two dates. There's final action dates and there's dates for filing. If you want to learn the difference between the two, I've done a video on, it's called Understanding Visa Bulletin. And I will be making another one probably in the next few days, because the April, because this is March 2023, April 2023 should be coming out anytime now, very, very soon. So I will be making video on that. So make sure to subscribe to this channel, and I will talk about the dates. I'll explain why there are two different graphs, what they mean. But for F3 category, since we know that you filed with USCIS back in 2017, and the visas are becoming available for people who filed back in November 2009. So that means between your case and what is being available as of right now, as of March 2023, there is 8 years of delay. So with that being said, 8 years of delay. Right now we're in 2023. Again, I'm getting into the mathematics of this, and I always make mistakes. So I'm probably not gonna go into the mathematics, and I will leave it up to you calculate. So 8 more years, all right? So let's see, 2009, yeah, 2023, yeah. So it's 8 years for you, but as of right now, it's 12 years. Wait, no, 14 years. Wow, that's a crazy delay for U.S. citizens. You see, it shocks me every time I look at it. Like, I get into it, I look at it, and it really does shock me. But the point that I'm trying to make in my answer is, don't let this scare you too much with USCIS processing, all right, in California. Because here, the only reason why it takes this long is because they wait to process these cases closer to the availability of the immigrant visas. So you have some more waiting to do, unfortunately, because there is a huge backlog. Again, like I said, I will be doing the updated video on April 2023. I really hope to see the backlog getting less in the April, but we will see. It really is hard to tell, because it depends on the amount of application that is coming in every year and every month, really, and the immigrant visas that are being issued every month. Unfortunately, there is a cap on the immigrant visas that are being issued, so it's not like we can expect all of a sudden more immigrant visas becoming available. It's just, if there is less applications coming in, then the backlog gets shorter. So we can just hope for that. But again, I will be doing an updated video on the April 2023 visa bulletin in the next few days. So hopefully we will have some better answers and better estimates. All right, let's move on to the next one. Next question from Aaronic TV. Hi sir, how do you pay the fees online? Okay, great question, very easy question. So once you're done with the application online, once you have filled out the application, once you have the submitted evidence, you have the application packages ready, you will have an option to pay it right there online, credit card, debit card. That's really it. Once you pay the fee, the application is already submitted. Very simple, very straightforward. Alrighty, let's move on to the next one from My Baby 2005. I'm trying to bring a cousin to help care for a family member. I'm not a company, but I will be paying her to help me out. What should I put under the company or organization name? Thanks for your help. Okay, so that was the question asked on I-129 petition for non-immigrant worker. So whenever it comes to the petition for non-immigrant worker, this is more for a company that is more established, that has a corporate structure, because the process is, it's a pretty complicated process, because you have to get the letter, the approval from the Department of Labor, and they have to review your petition. And the criteria basically for that petition is that the worker that you're inviting from a foreign country, you just cannot find someone like this here. This is not very applicable in your case, because really you can find a caregiver here. So I think in your situation you will be much better off if you just do something simple as, you know, just a regular non-immigrant visa, just inviting the person to come here, visit you on a visitor visa, B1, B2, something along those lines. And then if you want to kind of show them, you know, gratuity. Is that a word? I'm an immigrant myself, so my English is not fantastic. But basically what I'm trying to say is you gift them, okay? It's not a pay, it's not a salary, it's just a gift. It's a thank you gift for, you know, for helping you out, for helping your family member out. All right, and not an official employment. There is no employment contract. There is nothing crazy stuff like this, Department of Labor. You definitely don't want to be dealing with this. It will make it more complicated, and I wouldn't say that 100% you're going to be denied. Why? Because again, like I said, you have to have a corporate structure. You have to show, an organization has to show their income. An organization has to show that they will provide a certain amount of hours for that employee that they're bringing from a foreign country. I mean, I wouldn't recommend dealing with this regardless, unless you are a big company and you really are getting someone who you cannot find with certain qualifications here. So I think in your situation, the best thing to do is do a regular non-immigrant visitor visa, and then just, you know, giving a gift if you want to give a gift. Yes, I mean, it's not like I'm telling you to do that, but it's up to you. But if you want to, you know, help out that person for helping your family member out, then you just gift them. All right, so let's move on to the next one from Lula. My son I-130 approved when I was green card under 21 years on 2019 NVC, approved all the documents and paid all fees, and we were waiting. I become a US citizen and NVC throw his case as F1. Wow, that is messed up. Now he's out of his home country as refugee. Can we expedite his case? Lula, I'm really sorry that this happened to you. This is one of those, if whoever's watching, this is one of those examples, what they call aging out. And it's, honestly, it is ridiculous. It's completely ridiculous, because if you have applied for your child, right, and he was 20 or he was 19, treat it as someone who was applied while they were 19 and 20. Okay, of course he turns 21, because there is so much crazy amount of time to wait. It's ridiculous, and again, I don't want to start with my rant about the idiots that we have in the politics that think they know anything, but all they do is they try to promote their political careers at the expense of immigrants that go through these things, and that they have to deal with these things. It's nuts. But I would recommend, Lula, in your situation, because NVC already approved it, because they already documentarily qualified, unfortunately there isn't much you can do, because they put it in the F1 category. So with the F1 category, now you have to rely on the visa bulletin and see when the immigrant visa is available. Because whenever it comes to the expediting the case, the only cases that NVC would expedite, if there is a good reason, and it sounds like there is a good reason for your son, because he has the refugee status, the only cases that they expedite are those for which the immigrant visa is already available. And if he's a F1 category and it's 2019, let's take a visa bulletin. So 2019, 2016 here for the cases that were sent in 2016. So there is a 3-year delay. So you're looking at about 3 more years of. It's very rough estimate because things can slow down, things can speed up. And again, I'm gonna mention April 23 backlog visa bulletin, because that's really what it is. Visa bulletin is about backlog. That is the realistic name. They should just rename visa bulletin and call it backlog of visas for March 2023, for April 2023. But the April 2023 is coming out in the next few days, and we will see. Hopefully the things are starting to speed up because we had a huge delays because of the whole pandemic situation. But we will see if they speed up or they slow down. So there isn't much that you can do, unfortunately, in this situation. I wish I could tell you a little bit more, because whenever it comes to expedited requests, they expedite only cases that have the immigrant visa already available. All right, and in your case, there's about 3 more years to wait. So I'm very sorry, Lula, that you're dealing with this, and I wish I could give you a little bit more. Again, it doesn't mean that you can't reach out to NVC, to elected officials, to the senators, to whoever it is. If you're willing to deal with this, do it. Do it, and you never know. Maybe, just maybe, you will be able to do something and accomplish something. But again, unfortunately, whenever it comes to expediting the cases, it's only for the immigrant visas that are already available. All right, let's move on to the next one from Emmy. I think you pronounce it Nguyen, if I'm correct, because my friend actually is Vietnamese and his last name is Nguyen. But so anyway, can you submit I-864 at the same time as I-130? On the USCIS website, it says that I-864 is free of charge, but it looks like you have to pay for it on the Department of State. Have you experienced that? Okay, Amy, so great question. So whenever it comes to I-864, it's affidavit of support. Yes, so if it's free whenever you submit the affidavit of support from outside of the United States. If you're submitting from within the United States, you have to pay it. On the plus side, you don't have to deal with the I-864 at all separately if you're submitting the I-130, because as you submit the I-130, it goes to the USCIS. The I-864 actually goes to the Department of State for processing to show that you are a capable sponsor for the beneficiary that you are petitioning for. So you don't need to deal with it separately. Once your case is approved and transferred to the NVC, once you log into the portal, you will see the I-864 as part of the rest of the stuff that you have to do in the NVC portal. There will be the affidavit of support, there will be the visa application itself. Obviously, there will be a whole bunch of documents that you will have to submit, the financial documents, again, all of that identifying documents, birth certificates, marriage certificates, whatever. But it is done all within the NVC portal, so you don't have to worry about it separately. And if you send it to the USCIS, they really not gonna care for it, and they will once they transfer to the NVC, you will have to deal with it regardless. So might as well not bother with it now. Alrighty, let's move on to the next one from Francine Moro. My I-130 is approved. How long can you file your permanent resident? Okay, Francine, so I have great news for you. Once your I-130 is approved, once the NVC is done, again, it depends if you're here in the United States or if you're outside of the United States. If you're outside of the United States, once the NVC is done, the Department of State, they transfer the case. It's still within them. It's still part of the Department of State, but they transfer it to the consular section, to the local U.S. embassy, where they invite you for an interview. Once you go through the interview, you get the I-5, if you go through successfully, that is, you get the I-551 stamp in your passport, which is the immigrant visa that really everyone is waiting for whenever it comes to the I-130 petitions. And once you come into the United States with that I-551 stamp, and once you get the stamp in the airport saying that you entered the United States, that I-551 stamp automatically becomes a temporary permanent resident card. And if everything was paid, all the fees, all the applications within the NVC portal. Part of them is the adjustment status. So within the 90 days of arrival into the United States, the permanent resident card, the green card, arrives in the mail. Alrighty, so let's move on to let me post this, make sure this is and we're gonna move on to Wenjing Wang, and I'm sorry if I'm mispronouncing the names. Do I need to send a copy of both sides of the green card? Okay, so you asked the question on I-90, how to renew green card. You don't have to, unless the USCIS specifically requests both sides, you don't have to, but it's not going to hurt. So whenever it comes to cards, whenever it comes to green cards, permanent resident card, employment authorization document, IDs, driver's license, I would recommend submitting both sides, the front and the back. Again, you don't have to unless USCIS specifically requests that, but it's a good practice because, again, some of these cards, they do have identifying information at the back of it. I don't think employment authorization card does, unless they made some changes as of recent. I haven't dealt with the physical employment authorization cards for a very long time. The permanent resident cards, they do for sure. Driver's license, they do for sure. So it's a good practice. So it's a great question. It's a good practice to submit both sides. All right, let's move on to the next question from Vandna Kundra. Probably mispronounced that, I'm sorry. Your video was very helpful. Thank you. Thank you for letting me know. I'm glad it was helpful. Thank you for making it available for public. My mom came to USA on multiple entry visas. Okay, on 11/15/2022. Okay, for 6 months. Her ticket to go back is for May 3rd. Okay, so May 3rd, 2023, which is like just over a month from now. She will be coming to Mexico with us on 4/20 till 4/26. Okay, so while her stay here, okay, I want to extend her visa. I heard that it's better to file after we come back or she won't be able to go with us. I'm also the preparer for her application. Can I put my phone number, email as contact for her here in USA? She does not have a phone here. Should I file online for extension after 4/25/2023? I would appreciate your help. Oh, okay, Van, actually very, very interesting questions. So whenever it comes to the extensions of stay, as she comes back into the country from Mexico, it really depends on the port of entry. So I'm assuming you're going to be flying in, right? So when you're flying back in, once you're flying out of the United States and once you're flying in, that's going to be a different duration stay. So as long as her visa is still valid, the visa that she was issued, the visa in her passport, once she comes back into the country from Mexico, she should be getting completely brand new duration of stay, a brand new I-94. So chances are that once she gets back on April 26, she's gonna have another 6 months given to her of the duration stay within the United States. So I don't even think that you will have to worry about doing the extension at all. Now, whenever it comes to the extension of stay, if we are just scratching the Mexico completely out of the equation and assuming that she has to go back on May 3, you don't want to file the extension before leaving to another country, because if you file for the extension and you leave the country, if you leave the United States while that extension is pending, that extension request application completely it becomes void. All right, so you definitely don't want to do that. Another thing to keep in mind with the extension of stay is when you apply for it, you definitely do want to give yourself about 2-3 months, good 2-3 months, because these extensions, again, with this whole, and I know it's been a big problem, this whole pandemic situation, it created a lot of problems. And one of the problems is with the I-539, because whenever it comes to the extensions, a lot of people that have been here, they could not leave the country. So the amount of these applications that have been submitted, it grew like crazy in the past couple of years. So instead of usual about months and a half processing. These applications, I've heard some cases that take 6 months that have been, which is ridiculous because I mean, most of the durations of stay are for 6 months. So you're already kind of taking on the risk of waiting for extension to be approved while overstaying your duration of stay, which is never a good thing. You definitely don't want to take that risk. So in your situation, I think the best thing to do is I would see once you guys get back from Mexico and enter the United States, I would see what the duration of stay that they put in her passport, which most likely is going to be another 6 months. So you don't even have to worry about doing the extension, because by leaving the country and re-entering the country, you kind of getting the whole new duration of stay. So I'm gonna finish up on this question for the volume 38, and we'll be doing the volume 39 probably today or tomorrow, because there are a lot more questions that I need to catch up on. Always thank you everyone for your support, first of all, for your kind words. You know, if it was helpful, let me know, because by letting me know that my response was helpful, it shows me that, you know, the work that I'm putting into this channel is not in vain. All right, and as always, appreciate your time. God bless, and I'll see you in the next video.